Welcome back to the Student Hub Live. Okay, in this session, the last session of our induction event for the Open University Law School and the Open University Business School, we hear from the Open University Law Society. And I'm joined by Jennifer and Georgia, who are here to tell us all about mooting and how to get involved with the OU Law Society. Now, you've both been members of this, and one of the things that you do is to go mooting. Now, I think before we tell everybody what the Law Society does, it'd be great just to know what this mooting thing is, because everyone's been asking about it in the chat, and we're all very excited to learn more about it.
Mooting is a test of a person's advocacy skills, their persuasiveness, their legal research, and it is basically a competition in which you argue that a case has been heard incorrectly and it's now at an appeal stage.
Right, so this is something you do in the Law Society, and you basically have these sorts of competitions and events, don't you?
That's right, yes.
And they vary in terms of what you do. I mean, could I just ask what your best moot has ever been?
My favourite moot was the National Speed Moot. This is a competition that takes place every year in different places across the country. You're given all of the information the night before the competition. So there isn't any research element as
or
there
sleep.
is. No, not much sleep either, because of course you might be travelling to the other side of the country as well. And then you present submissions.
Wow.
And it's what it sounds like, a speed moot. So you have 5 minutes to give your submissions, your opposition has 5 minutes, and then one of you's knocked out and the other is through to the next round.
So the challenge is to really clearly articulate an argument succinctly and with conviction.
That's right, yes. And there's a skill in that, and that is what we teach our members.
And so you can sort of see how, I mean, we've been talking about experience and how important that is, in particular for law students, to get that experience. You can see how this would be a really clear way of honing your study skills, your persuasive skills, and I guess your ability to present in court. That's
right, yes. So it is, it's a mock courtroom scenario of an appeal case, and you will be grilled by the judge, and you might be criticised by your opposition, and you have to hold your nerve and present your arguments confidently.
What sorts of moots have been your favourite, Georgia?
In the past year, my favourite moot has been the Inner Temple InterVarsity moot, and in a nutshell, what happens is we were sent out our original moot problem about a month before, and in teams of 2, we had to create arguments for both sides. And we had to be very, very thorough about knowing the cases, knowing the law, knowing the arguments. And then teams of 2 from universities all over the UK came together in London and were told about 2 to 5 minutes before the moot, this is the side you'll be representing.
Wow.
Perform.
Gosh.
And so it was a sort of knockout competition with the ability to go forward throughout the day, and you wouldn't know who you were mooting against, and you wouldn't know which side you'd be doing up until right beforehand, which made it for a very lovely atmosphere, because you couldn't get too wound up and in your head about how you're going to perform, what the other side is going to be like. You just have to get up and do it.
I mean, I'll be honest, it sounds absolutely terrifying.
Yes, I would say that. However, what I've learned to tell myself is that what is going to happen is a conversation that happens with an incredibly knowledgeable person, a barrister or perhaps a real judge, who is able to talk to you and help you develop your opinions and your style and your performance in this area of law. And they're an expert, so they know what they're talking about. And that's one way to test whether or not you actually understand the subject matter, which is something that I think a lot of Open University students don't get that opportunity to see. Oh, am I actually any good at this? Can I hold a conversation with a sort of very serious member of the profession in this area?
So it's great experience. And just sort of going into, I guess, the more of the what is it, there's a distinction between a moot and a mock trial, isn't there?
Yes, that's correct. So a mock trial, I think a number of secondary schools, I certainly did one in secondary school, will give you the opportunity to stand up and have someone play a witness and someone play the defendant, and then you come in and you say, did you do this? Where were you on the night of? And so it's sort of very much a performance role. Whereas in contrast, a moot is rather, perhaps Jennifer should take over at this point, but it's the opportunity to take it from beyond that court of first instance. It might be told, it might be whether someone has committed a crime, this is their punishment. The moot is the opportunity for the person who's been charged with something to turn around and say, well, no, actually, I'm appealing because you didn't interpret the law properly. And so that's what the moot becomes, this question of how is the specific law on this matter interpreted.
Right. So you're really having an argument about the application of the law in something that's already happened, and you're looking maybe at precedents and sort of ways of interpreting and persuading the judge, in a sense, that this is a better way of interpreting this. I mean, that's a very diplomatic skill indeed for something that's already reached a decision.
Yes, that's right. So what you need to do is you'll get the scenario, you know what the problem is, and you need to find some law from a previous case that has had similar facts, and you will find cases that support one side of the argument or the other. So you need to find the ones that support your argument, and then you need to tell the judge why, in this current case, they should find as in the case that you're citing.
Wow. How do you find all of that information then? Are you going off and looking at previous cases on the library and in various databases? You must have to use quite a lot of primary research to get evidence to support your particular line of argument.
That's right, we do. There's a skill in legal research that crosses over, not just with mooting, but it also helps you in your studies. So there's a research element to the law degree. And so it's really beneficial to, it helps with your skills of using the various legal databases. And then you'll find one case, it leads to another case, and it's certainly very beneficial for law students.
So people are talking about various sort of mooting activities, and Michael says that there's still one in Edinburgh this weekend because Katie's really gutted that she's missed out on the mooting workshop. There's lots of chat going on about mooting at the moment. So these workshops then, do you go and learn how to do this? And you've mentioned that there's more than one person, so I'm assuming that you can sort of start and gently, really, maybe not having that centre stage.
I wouldn't say that exactly. We've just had some workshops. The Open University Law Society has run workshops in London. That was last weekend. Yeah. Manchester is the weekend just gone, a couple of days ago. And we've invited our members to come and learn about mooting. So we've given presentations, we've given a demonstration like the one that we're going to be doing later. And then we've been doing some coaching, and we've helped the people attending to research a problem that we've set for them. And then we've given them the opportunity to have a go at giving their own submissions. And Michael's quite right, we do still have a workshop coming up this coming weekend in Edinburgh. That's on the 30th of September and the 1st of October. So we would welcome anyone watching to contact us if they'd like to come.
Okay, so we're going to talk more about mooting. I mean, this whole session is about mooting. But let's go through what the Open University Law Society actually do, because you're a society set up by students to support students in their studies. And there are a number of these OUSA, the Open University Students Association, affiliated societies here at the OU. But this one seems particularly relevant to OU law students. Is everyone a member?
You're not automatically a member. If you would like to become a member, you don't have to be a law student. You can be studying anything with the Open University. And if people do want to become a member, it costs just £5 and they can sign up on our website.
So Mohan has said, by the way, could he have a moot in Birmingham, please? And I guess this is one of the things, I mean, I've worked a lot with the societies and it is run by volunteers. I mean, I know you two have been travelling the length and breadth of the country delivering these workshops. How easy is it to set up these in different areas? And is it as simple as just saying, well, I'd like one here, you know? How are you sort of factoring in all the members you've got to meet the demands of the students?
We, as I'm sure everyone can understand, we do have a limited budget and everyone is spread across the country and we would love to go everywhere, but we do have to focus our events where there's a demand for it. So what we would say is please contact us and tell us what you would like and where you would like it, and if there's enough demand, we'll go.
And do you have volunteers then who can assist you with organising this? Is that what becoming a member is, or can you become a member and just attend some of the workshops or the moots? How does it work in terms of your committees and your sort of structures, getting all these things ready for students?
We have a committee, people who have been elected into their post, and the elections were in March of this year. And I am one of the two mooting coordinators, so it's myself and my fellow mooting coordinator that's organising the workshops. And then other committee members come to help us, and we also invite other experienced mooters like Georgia to come and assist. So Georgia's going to be really helping us out in Edinburgh this coming weekend.
Sally says that she learned so much last weekend. She's watching now from your weekend in Manchester, and she'd love to go to the Edinburgh one as well. So that's really nice feedback.
Yeah, we'd love to see Sally again.
Oh, good. And Mohan has changed his mind from Birmingham and says, could we just have something online then?
Georgia.
Yes,
So
wow.
he can then talk to the other team in his pyjamas, which has been an ongoing theme of today's discussion, by the way.
There is, I believe, this coming year a digital moot that is just being set up, and whether the Open University will be able to enter that in the coming years would be very beneficial, as there are students all over the world. What I would say, if people want to get a leg up without having to leave the house, the two main legal databases that the Open University Library provides us access to are Westlaw and Lexis Library. And both of those have a free certificate you can do that guides you through those databases, that teaches you how to do legal research using those resources. And some people prefer one, others prefer the other. And I was hardcore on the team Lexis when I began, but then I did the Westlaw certificate, as it were. You get a little digital certificate that you can put on your CV, which is always beneficial. And now I'm a Westlaw convert. But it does teach you how to really use the databases to their full potential. And that's one of the key stepping stones to beginning to moot. You need to know where to find the law and be comfortable with doing that.
Yeah, no, everyone's mad for moots. I mean, Gwendolyn wants them in Surrey, Sophia wants them in Brighton. Yeah, so there's a lot of love for these things, and it's really clear what sort of benefits you would get from them, both in terms of your study skills and your research skills, but also this idea of articulating arguments clearly and succinctly. Now, we've had a question about, are you disadvantaged if English isn't your first language? I mean, it's something that is relying on very quick thinking, persuasive arguments, and I guess quite a lot of clarity. What would you say to students who English isn't their first language?
Well, what I would say is, if they are competent enough in the English language to be doing a law degree in English, then that would be absolutely fine. There are people who have English as a first language who can't moot. They can't speak, they can't think on their feet. So I don't think it would be a problem at all.
Brilliant. What about, Lyra wants to know, she's got kids. Can she bring kids along? I mean, is this something that would be appropriate or not?
Unfortunately, just as with tutorials, I believe it's not really appropriate to bring young children, just because they may be a distraction and it wouldn't be fair on other people. But we do understand that people have childcare commitments, and we would try and accommodate that, but you can't bring children to the competitions.
Oh, OK, no, fair enough. Nicola's also somebody who's been to Manchester last weekend who really, really loved it. So you've got a following, so that's good.
Excellent.
What else do you do at the Law Society then, apart from the moots, and how else can students get involved?
We try to put on social events, so after events like the workshops that we've held recently and also the upcoming selection day, we try and have a social gathering, and even if you're not attending the daytime event, we would invite all of our members to come and join us for the social. There'll be a Christmas party that's in the planning stages at the moment. And also, throughout this year, we're going to, wherever possible, invite members to come and support our mooting teams as they travel across the country, because it's nice to have that support.
Yeah.
And it's really nice as well for our members to meet each other, because as OU students, we often don't have that.
Yeah. So how do they find out? Do you have an email or do you have a Facebook page?
We do have a Facebook page. If you're on Facebook, you can search for Open University Law Society and you'll find us there. Our website is OULS, which is ouls.org. And if you'd like to contact us regarding mooting, our email address is mooting@ouls.org.
Brilliant, excellent. So I'm very excited to see what happens in a moot. So could we do some like a little sort of taster session? That would be great. And then we're going to take questions at the end. So do keep those questions coming if there's anything you want to know about the Open University Law Society or indeed any advice from our students. Okay, so we're going to do a case that you've been working on recently.
Yes, this case it's based on real law. So it's based on the Road Traffic Act 1988, and it involves a man who has been convicted of drink driving. The matter in dispute is not whether or not he was drink driving, it's the location in which he was driving. And the law concerns whether or not that area was a public place or not. He says it was not, and he's appealing.
All right then. So we've got an appellant.
I will be representing the appellant.
Okay, and we've got a counsel for the respondent.
Yes, that would be me.
I'm going to be the judge.
Yes.
Which means I'm going to be a little bit harsh.
Yes.
All right. Okay, so you can come up here then, and we can start making submissions.
My lady, may it please the court, my name is Jennifer Wharton, and I am counsel for the appellant, Lord Asquith de Ville, in the instant case. My learned friend opposite, Miss Georgia Palmer, is counsel for the respondent, the Crown. Before I begin submissions on behalf of the appellant, would your ladyship appreciate a brief summary of the facts of this case?
I would.
The appellant is a wealthy landowner, and after hosting a New Year's Eve party at his sprawling mansion, he drove his new 4x4 car through parkland on his estate. The parkland was the appellant's own private land and had a fence surrounding it with a large gate which needed to be opened in order to gain access. The parkland was used for various events throughout the year, the most recent of which was a Christmas fete. Pupils at the local secondary school also used the parkland as a shortcut to reach the nearby school. The gate had been closed on the night of the offence until a party guest opened it at the appellant's direction. The appellant was apprehended by the police and charged with driving in a public place with excess alcohol in the breath, contrary to Section 5, subsection 1, subsection A of the Road Traffic Act 1988. He admitted driving with excess alcohol in his breath. My lady, this point is not in contention. But he claimed that the parkland was not a public place for the purposes of the charge. He was found guilty at his local Crown Court and now appeals against his conviction on the ground that his privately owned land is not a public place. With your ladyship's permission, I will now begin submissions for the appellant.
Yes, please begin.
My lady, it is our submission that the onus is on the Crown to show that there is use of the area in question by the public generally, and that it is a public place for the purposes of Section 5 of the Road Traffic Act 1988, as established in the case of Pugh and Knight, as reported in the Road Traffic Reports for 1972 at page 286. My lady, in the interest of time, may we dispense with full citations?
Yes, certainly.
I'm grateful. Would your ladyship appreciate a summary of the facts of Pugh?
No, I'm familiar.
There is a distinction to be made between members of the general public and people of a special category. My lady, the next case on which I seek to rely is the Crown against Spence, which your ladyship will find in the bundle at page 35. My lady, in Spence it was held that a car park used solely by people of a special category, and in that case it was employees, could not be defined as a public place.
Yes, but Miss Wharton, our case involves a field, not a car park. So are you telling the court that these are the same thing?
I'm grateful for your ladyship's question. It is our submission that the principle from Spence regarding the car park applies equally to the field in our case. People invited to a party are not members of the public. They are people of a special category, and as such, the area cannot be a public place.
So you are saying that an area cannot be a public place unless it is open to the public?
That is correct, my lady.
And that guests at the party are not the general public?
Yes, my lady, they are members of a special category, invited guests.
I see.
With your ladyship's permission, I will move on to my final submission.
Yes.
May I direct your ladyship to the case of Cowan and the Director of Public Prosecutions, which you will find at page 88 in your bundle.
Yes, I have it.
We ask this court to apply the principle established in the court in Cowan and hold that as guests of the appellant's party were present for a specific reason and for their own purpose, combined with the lack of use generally, the field is private and cannot fall under the definition of a public place. Unless I can be of further assistance to the courts, this concludes submissions for the appellants, and we ask that the appeal is allowed.
Thank you, Miss Wharton.
My lady, as my learned friend opposite has said, I am Georgia Palmer, and should it please the court, I am counsel for the respondent in this matter, the Crown. I seek to address your ladyship on our response to this appeal, namely, that the status of the land on which the offence was committed by Lord Asquith de Ville was indeed a public place, and thus the conviction of driving in a public place with excess alcohol in the breath under Section 5, subsection 1, subsection A of the Road Traffic Act 1988 should stand. With your ladyship's permission, I shall now turn to my submissions.
You may.
The field is a public place under Section 5, subsection 1, subsection A of the Road Traffic Act 1988 because it is accessible to the general public and not restricted to a specific class of person. If I might direct your ladyship to the case of the Director of Public Prosecutions and Vivier, is your ladyship familiar with the facts of this case?
My memory is failing me.
Well, my lady, if you might turn to the page of the bundle. This was a case in which the appellant was charged with driving dangerously in a public place. It was said that at first instance the jury direction was flawed because it admitted the legal necessity for evidence of actual use of the car park by the public, rather than just whether or not they could have access.
Okay. Thank you.
The evidence of such actual use by the public of the land in question shows that the legal necessity is fulfilled, and in the case of the appellant, his land can and does amount to a public place. My lady, in conclusion, we submit that Lord Asquith de Ville of Rochester should be found guilty of the offence of driving in a public place with excess alcohol in the breath on the grounds that the field in question at the time of the offence, on the facts, cannot possibly be construed as anything other than a public place, and therefore that this appeal should be dismissed. Unless I can assist your ladyship any further, this concludes the case for the respondent.
Thank you. Right, so thank you very much. That was a very short example of some of the things that you might be doing. There's a lot of legalities, a lot of procedures involved in some of this. Is that difficult?
Well, there's formalities, such as referring to the judge as my lady, asking for permission for certain things, and that can be a bit overwhelming at first. But I was saying at our workshop recently, you get used to it. Yeah. So that starts to come naturally, and then you can focus on your actual submissions.
Now, this isn't a sort of case where normally what would happen is this would sort of go on for a bit longer, and then the judge would retire and make a decision based on who they felt had made the most persuasive arguments and who had won the overall discussion. But it was something that we sort of felt wasn't appropriate in terms of who was right or wrong. But the chat room are talking about, this sort of thing as well. And, it's a very sort of complex issue. So can you tell us then how these things are sort of graded and how they're assessed? And I guess, really, what you learn from those assessments.
Yes, of course. There are a number of different ways in which it's marked, and it can depend on the competition itself. But one of them is courtroom etiquette. So that is saying my lady or my lord, your ladyship, your lordship, and using those in the correct sense. So if you would say, if you could turn, it would be if your ladyship could turn. And the way that you would then handle the style of your argument and any such interventions. There are cases in which the judge may try to trip up the person presenting and say, okay, but can you maybe do this differently, or perhaps you've written this badly, can you explain yourself? And it can become a little bit accusatory, and the challenge of the mooter is then to stand up and handle it with grace and style and be able to sort of hold their own following the etiquette. Another sort of way in which it's graded is the style of your argument in the skeleton argument. Now, this is the piece of paper on which all the arguments are based, and there's a specific style that needs to be followed. And the presentation, the layout, the font used is all sort of an important part of making it look uniform and professional. And so you're based on the presentation and then also the content as well.
So the skeleton argument is something that you construct in advance of the moot that basically sets out your rationale for arguing a certain course. But it might be that evidence comes to light, or in particular when you're mooting, that there are other instances that you might want to draw on. So how important is that skeleton argument then, and what parameters you can sort of use in the moot?
Well, the things that might be thrown at you is a case you perhaps hadn't thought of. Now, most people would have exchanged the skeleton argument, so you would get to see in advance what the other side is going to say, assuming that they follow the rules and follow their skeleton argument. You'll know.
Does that happen?
Yes, most of the time. Most of the time. But you'll be able to see the authorities on which they're going to rely, so you can read those cases, read those judgments, and try and work out in advance, how are they going to quite argue this? How are they going to frame this? What questions is the judge going to have? And how is my case better than theirs on this point?
Wow. OK, let's go to the hot desk because I know that there have been a lot of people who've been at your mooting workshops, and I bet there are a lot of questions here. So Aisha and Kate, what are you guys all talking about?
Yeah, thanks, Karen. So there have been lots of people chatting about kind of the formality of the process. So Bree said that both our participants look formal and ready to take you on in court. And Gwendolyn also said that she really likes the formality of the process. So there's lots of discussions about the structure of it and how it's working.
I think Lyra's really interested, says it sounds like an interesting case, and a lot of people are saying the way that you talk during the process is very interesting as well, and I'm sure the workshops really help with sort of getting into that mode, as you were saying. And there's a few people that are waiting for the judgment. They want to know, so have you argued this before, and what was the outcome?
Well, it's actually... I wrote this scenario, so we haven't argued it before.
But it's based on a real case, isn't it?
It's based on real law.
Right.
And yes, in reality, there would be much more information given and many more cases used. So you can't really judge based on what Georgia and I have done.
On the, we did argue something a bit similar, and on the facts of that case, it was decided that it did not amount to a public place on those facts. And these are slightly different, but if that sort of whets the appetite a little bit, it is this, the key question is whether it is public, whether it isn't public, because that hinges on whether his actions were illegal or not.
Now, a lot of this is based on precedent, and you're using research to sort of back up cases that you're then sort of relying on. But at some point there must be a new precedent. And so is the idea, would your sort of claim to legal fame type thing be in establishing a new precedent and establishing a new trajectory of arguments that can sort of make something new? Would that be something you would aim for as a law student?
In a moot.
Either in a moot, or I guess maybe possibly something like in real life in terms of application of your law degree. You know, people are doing it for very, very different reasons. But is that something that you think, I mean, from a personal perspective, is there an idea that you want to sort of push boundaries with law, or is it really much more of a case of actually supporting precedents and using those to support where things are at the moment?
I think it's always easiest if there is a precedent that backs up your argument, but of course if you get a case that you have to argue the other way, then you would be looking to have a new precedent set because you want the court to go your way.
I would absolutely, sorry to interrupt, I would absolutely want to be pushing the boundaries, because that's the way that we can make sure that the law keeps up with the way that society is developing, and that's one of the beauties of the common law. It means that, you know, as digital processes come into play, we've got digital privacy, we've got so many different issues that sort of are changing and rapidly developing that maybe the law can't keep up with technology. And so pushing boundaries and setting legal precedents, that's the way that we can keep up with the modern world.
Absolutely. But yet there is a lot of formality within these moots. And Simon and I were talking earlier about how, you know, there have been changes in terms of how the legal system is presented. So is there a sense that in the future, mooting might be slightly less conventional? Are those conventions changing? But it does seem to me that, you know, to some extent, the convention is a real part of the moot experience in terms of the way that, you know, the judge would behave and the language that you're using and how that's important in terms of preparing you for court. So how do moots relate to then what a court is really like? And is there a sense that that will shift as courts become slightly different in terms of the way they present?
Well, in reality, people are using laptops in court more than they're using the actual bundles. And again, in moots, you may have a hard copy bundle, but equally you might prefer to use a laptop. And this digital issue and the technology issue is as relevant for mooting as it is in the real world. But something that's going to be a lot slower to change is the actual formalities. I can't see a time anytime soon where you're not calling a judge my lord.
Well, in fact, the chat room is in hysterics right now because apparently the word buttocks was used in a moot.
Oh, yeah. Yes. At our recent workshop, it involved a very interesting case. It was a bit of a racy problem, which did involve an injury to somebody's buttocks.
Lots of giggling going on. Stop it, you lot. Yes, so people have been asking about videos of moots as well. And Mohan, you can get the videos on YouTube, and lots of people can't wait for the mooting workshop. So yeah, it's really, really brilliant and valuable. Okay, so let's just sort of sum up then in terms of being law students at the OU. What advice would you give to students apart from joining the Law Society and getting engaged with some of these activities? But from your experiences, what would you say is really important, bearing in mind we've got a lot of level 1 and 2 students in the chat right now?
It's important to know what you want to do with your degree and how you would go about doing that. So the OU has a really good career service you can contact, and just make sure that you know stage by stage where you need to be applying to, meet your deadlines, network as much as possible, and joining our society will help with that. And yeah, just take advantage of everything that's offered to you from the OU and the Law Society.
What would you say?
I would add further, step 1, find your local court, the Crown Court preferably, for an interesting case and go sit in it and just get a sense of how it happens in real life. and try and get as much practical experience with seeing the formalities if you're interested in mooting. If you're able to seek out other opportunities, perhaps contacting your local law centre to see if there are any volunteering opportunities, or just even shadowing as well. Citizens advice can give you a good opportunity to meet clients face to face and provide advice. I believe that there's a virtual reality module now that gives you the opportunity to give advice. But if you want to hone that experience, that's something that can be done through some sort of advisory charity.
We've already had 2 people who've gone to the CIB, the Citizens Advice Bureau, today. And I know a lot of students will get engaged with things like that. And we've also got the Open Justice Project as well. What would you say to those students who are seeking active placements where they can start practicing?
Try everywhere.
Yeah,
Depending on where you're at in your studies, one thing that I've found incredible is something called the Free Representation Unit.
Right.
And that is based in London. And what that does is gives students who are in their second year, beginning their third year, the opportunity to represent real-life clients with real-life problems at social security tribunals. And once you've completed your degree, you can then graduate on to employment tribunals as well. And that gives you the opportunity to create a skeleton argument, to speak with judges. Well, it's a slightly more informal process, but you can do some real good for people who wouldn't have representation any other way.
And we've put a link to that in the chat box, so if you're interested in that, you can click on that now.
And another one, if you're perhaps unable to get to London specifically, there's the National Centre for Domestic Violence. They do take on volunteers. It would be a case of getting in contact with them, another charity that provides help with emergency court injunctions, which can be quite harrowing. You go through training on how to talk and how to prepare, but then you're taking witness statements and helping people achieve safety through a quick turnaround, 24, 48 hours, and getting legal aid through to them as well.
One of the things we've been talking about a lot today is this idea about emotions and how to stop those emotions getting overwhelming, I guess, when you're dealing with some complex and difficult cases. I mean, Sophia has been saying, you know, she's worried about getting emotionally involved in a moot, for example. And I guess if you've invested so much, it must be really hard. But equally, you know, when you are practicing and even studying, there is that sense that some things can be very, very difficult. How have you both dealt with that? And what advice would you give to students who might be just embarking on their study of law? How could they deal with it?
Well, I think everyone understands when they start studying law that the reason that we have the law is because bad things happen in the world and there need to be rules and not everyone follows the rules. So you are going to come across cases where something awful has happened and you're going to read all of the details of that and you're going to have to give your opinion and analyse these things. So people do need to be prepared for that. But then, of course, it's not all dreadful cases. There's some humorous cases, there's some boring cases, but I think people embarking on the degree understand that they will come across distressing cases.
I mean, I would add that it's a steep learning curve for, I think, even very, very experienced people. Certainly, I've found value in seeking out charities in which I can begin my exposure in ways that are set up with support within each charity, because a lot of things are confidential. You can't talk about it, obviously. So if there's someone there, a supervisor, someone, you know, a problem shared is a problem halved. It's not something you should keep to yourself if you're having difficulties, struggling with the emotions of something that you're going through. I mean, when it comes to moots, it's slightly different. I think in terms of the competition, you can get emotionally invested.
Yeah.
In terms of the case, I don't think anyone would need to worry, because once you've started reading 50 pages of a judgment and then thinking, oh, now I have to read the next five judgments, you do get more analytical and you do sort of look at it in a slightly different light. So if if people are worried about taking part in mooting because it might be too emotionally challenging, I'd say just jump in, feet first. It'll be fun. It'll be fun in the end.
Well, you've certainly inspired a lot of people who have been involved with your mooting workshops and who say it's great fun. So I think that's testimony to what you're achieving. And well done, because I know you put a lot of dedication into this. And thank you for coming along and giving us a little taster of what it's all about and telling us about the Law Society.
Okay. We would like to say as well that the workshops were being held in preparation for our selection day. This is going to take place on the 14th of October, and it will give people the opportunity to try out to get a place to moot externally for the Open University Law Society.
Wow.
So we will be sending information out to all of our members. So if you would like to be involved in the selection day, or even if you just like to come and watch because there will be mooting going on, then you need to sign up at our website or contact us.
Brilliant. And we'll put a link to the OULS in the chat as well, so you can connect with them and sign up, etc. That would be brilliant.
Yeah.
Lovely. Well, thank you both very much for coming along today. That's been really, really brilliant. I've really enjoyed that.
Thanks for having us.
HJ and Kate, what were your final thoughts on the whole day's activities, and any final questions that we need to answer before we go?
Well, it's been a great evening. I'm really glad I've been able to join you. Really enjoyed all the sessions. There's been so much going on in the chat. People are really loving the moot. We do have one question for our Law Society representatives. So Lyra's asked, is it worth joining the Law Society if you can't attend events?
Good question.
It absolutely is. We're always available to chat to on Facebook. We can be contacted via email. We keep people involved. We have a newsletter that we send out to our members. So that will give key dates, deadlines for pupilages and that sort of thing, and other events that are going on. And it's really nice to be part of the society. So I'd recommend that anyone joins.
Brilliant. HJ?
I just think we've had lots of fantastic chat today, and there's been lots of great tips and resources, and it's great seeing lots of new students come around and lots of continuing students and supporting each other, and we really love that. And just a shout out to Anne, who's a law lecturer that's joined us all day today in the chat and has been helping everyone, and it's fantastic. And it'd be really nice to see a lot of people at our next events and see how you're getting on, starting off with your modules, and yeah, so hopefully we'll see you soon.
In fact, tomorrow, if you fancy it, we've got a boot camp session in the morning from 10 until 12, and we'll be looking at skills for your study. So we're doing reading and writing and note-taking and all sorts of fun things. So if you've enjoyed today's session and you'd like to find out more, then do connect with us tomorrow from 10 till 12. Then in the afternoon, we've got some more sessions also. But on behalf of the Open University Law Society and the Open University Business School, I'd like to thank you for coming along today. I really hope that you have enjoyed the sessions. If you haven't clicked on our final widgets, if you could let us know whether you've learnt something new today, if you feel more supported in your studies, you know what to expect as a student, and you understand a little bit more about how the curriculum works, then do let us know. You can also put any final comments in the chat, which will be open for another very short period of time. And also you can send comments to us on our email, which is studenthub@open.ac.uk. You can see on the website all the events we've got coming up, and if I could just let you know that we've got an essay writing workshop, which is for all students. So as you're progressing your studies, do come along, and we'll be offering you some guidance and advice, but most importantly, some peer-to-peer support as you work through your first assessments if you are with the Open University. That's for any student at any level with any assignment. Bring them along and we'll sort it all out together. So thank you to all our participants for the fantastic and varied selection of discussions that we've had today. If you've missed some of it or you'd like to watch again, it'll all be available on the catch-up very, very soon, so be sure to check that out. And we've also got a YouTube channel, which will give you lots and lots of content that could be really useful for your studies. Things like how to submit your TMAs, how the online rooms work, the virtual learning environment, all sorts of essential things are on there. So check out the Student Hub Live YouTube channel also. But that's all from us here today at the Student Hub. I hope you've had a good day. Good luck with your studies. It's going to be absolutely amazing. And I hope that you join us for another Student Hub Live event very soon. Bye for now.